Now the next point which you have to refer, that is what are the relevant Indian legislations to tackle with these problems. So there is first convention legislation that we have to discuss, that is the Air Prevention and the Control of Pollution Act 1981. Now this Air Prevention and Control of Pollution Act 1981, there the main task of the Pollution Control Board is to improve the quality of air and to prevent the air pollution also. Now this is not the only objective of this pollution board. There are other objectives also. They have to inspect the overall environment at regular intervals. So there you can say one thing, that protection is another thing, maintaining the standard is another thing, but inspection at a regular interval, it's also a very challenging task for the pollution control board. But apart from that also, they also need to do a kind of a check and balance on the level of emissions which are released, which are discharged from different industrial plants. So this is an important task. This is the kind of important responsibility upon the pollution control to tackle with these problems. And whenever they find any kind of pollutant, any kind of industrialists who are exceeding the limit, or where the emission of gases which are exceeding a particular limit, then they need to provide the penalty for the same. So this has been mentioned in the this particular legislation of 1981. Second point, which is related to Water Prevention and Control of Pollution Act 1974. Now this Water Prevention of Control of Pollution Act 1974, it has referred that the state that the Pollution Control Board, they have to prevent the pollution of water through industries, through agriculture, and through the household water also. So there they have mentioned that it is important that the proper examination of the level of different water pollutants has to be done, which are coming through industrial waste or which are coming from the hospital waste also. So you see again the same, like in the case mentioned in the case of prevention of air pollution also 1981. In this legislation also the same thing which is mentioned, that is there has to be a provision for penalty for the polluters also. At the same time, wherever it is necessary, the cess for these industrial units can be increased as per the quantity of the discharge of the emission of the waste also. So there these two legislation plays a very crucial role altogether. Next particular legislation which I am going to discuss about environmental harm, that is the Forest Conservation Act 1980. Now in this Forest Conservation Act 1980, there is one peculiar feature which is mentioned, that is even if any commercial entity, any commercial enterprise, if they want to convert the forest land for a non-forest purpose, they need to take an approval and sanction of the central government. And this particular legislation, either with respect to Forest Conservation 1980 or either with respect to Forest Act 1927, there the one thing which is important, that the forest offence has been clearly mentioned and has been said that there are certain acts which prohibited the reserve forests. And apart from these things, an alternative remedy has been mentioned under these legislations related to forest conservation for the against the deforestation, that is the afforestation scheme. Now this afforestation scheme seems to be one of the major alternative remedy which has been commonly used by many different countries also. Now dealing with these issues, it has been mentioned that time and again it has been emphasized for the legislators that we need to come up with one particular provisions which can regulate over the rights of these forest dwellers. So that is why in the year 2006, the rights of the forest dwellers has been legally recognized altogether. Now this another thing which have come about, another legislation which is important here from this point of view, that is the Wildlife Protection Act 1972. In the Wildlife Protection Act 1972, there are many things, there are many specific peculiar features which is mentioned also. For example, the first and the common principle that is mentioned, that is the prohibition of hunting. Second thing which is important here in this regard, that is the management of the wildlife habitat. Management means their sustainability is also very important here. It is also important, and it has been mentioned there, that we need to establish certain protected areas. Why the establishment of protected areas is important? For the purpose of conservation, for the purpose of preservation also. So there in these three points which has been mentioned in this Wildlife Protection Act 1972, it is also clearly has been given that there cannot be commercial exploitation of forest produce either in the national park or either in the wildlife sanctuaries also. So there these things which has come across when it has been mentioned that no commercial exploitation. At the same time, to bring a fine balance between the commercial use, they have said that we need to regulate the trade of the forest produce, which has been derived from the wildlife also. So these are the these are all the concepts which has been mentioned under the Wildlife Protection Act. It has been mentioned that they are basically talks about the community reserves. They are basically talks about the conservation reserves also. Now the next legislation which I am going to discuss, that is the Environmental Protection Act 1986. This Environmental Protection Act 1986, the concepts like environmental pollutions, it talks about occupier, the definition of occupier. It also discusses about the scope and the adverse implications of the hazardous substance. Now, in these Environmental Protection Act 1986, the central government has a very specific power to regulate the trade and make the rules governing the environmental pollutions, and or deciding what is the maximum limit for the pollutants of air, water and soil for various purposes. This is also not the same things. There, in these situations, there is a specific power of penalty has been given to the state. In those situations, in those cases where there are certain industries who are exceeding the limit altogether of emission of the gas, and those who are polluting the water also. So there, these penalty provisions which is there mentioned also, sometimes in many cases where penalty may not be an appropriate remedy. So in those cases, it is the main responsibility of the state to cancel the authorization of any factory also, wherever it is required. So you see, this Environmental Protection Act, though it is a general act, but basically it talks about the penalty. It also referred about even to go to extent of cancellation of the license of those factories, those industries also. Another important legislation that we have to discuss, that is the Public Liability Insurance Act 1991. Public Liability Insurance Act 1991 basically refers about immediate relief for those persons who are affecting from the use and the application of hazardous substance. Now this legislation is very peculiar. Why? Because it refers about no fault liability also. It also talks about that in these public liability insurance can be given to those persons basically who are affected with these things. And there, in this particular legislation, it has come into picture after the Bhopal gas tragedy. So where it has been mentioned that sometimes it is difficult to quantify the damage, it is difficult to quantify the loss also. So this Public Liability Insurance Act, to some extent, they are providing kind of a relief, an immediate relief to the those affected persons from the use of the hazardous substance. There's another legislation, another issues which we are going to discuss, that what are the legal issues which are related to the hazardous waste. When referring about the legal issues related to hazardous waste, we have found out that there can be liability for the overall this escape and release of hazardous waste in the process. So while they can come into picture in the case of improper landing, storage and other issues also. So keeping in mind all these legislation, and while understanding the scope and the you can say the nature of this legislation, we know one thing, that there are certain judicial decisions, Indian judicial decisions, which play a very crucial role also. For example, we are going to refer, that is the Vellore Citizens Welfare Forum versus Union of India. In this particular case, two important points which is to be mentioned. One, that is the precautionary principle. Second one is the onus of proof altogether. It is upon against those against whom the allegations of the pollution has been made. So you see, this is a kind of a reverse burden of proof which has been mentioned altogether. That it is upon those persons who has been alleged that these persons are responsible for creating and disseminating the pollution also. So these two principles has been mentioned in this case also. There is another case, that is MC Mehta versus Union of India. That case also is related to Taj Taprezian case also. Now in this particular case, one issues which has been mentioned, that the direction should be issued to the different industries, so that they can so that they can shift their business outside the Taj Taprezian also, which can affect, because as a result of which their commercial actions have affected badly to the living beings and other things also. So you see the environmental risk which has been mentioned in this particular case, where the protection and the preservation of environment has been mentioned. Now there is another case, there is the rural litigations and entitlement Kendra versus State of UP. Now in this case, the Supreme Court has ordered the closing of an limestone quarrying in the hills stations also, where it has been mentioned that we need to protect and safeguard the rights of the people so that they can live happily, so that they can have a quality life of the environment also. So in this perspective, where it basically talks about that they should, whatever commercial activity has been done by any enterprise, there should be minimum disturbance of the ecological balance. So this is the most important point which has been referred in this particular case. Now there's another case which is very interesting, has come into picture, that is Deepak Nitrate Limited versus State of Gujarat. Now in this Deepak Nitrate versus the State of Gujarat, a kind of a point which has been made by the Supreme Court, that there is a non-compliance of the norms which has been laid by the State Pollution Board also, State Pollution Control Board. And in this particular case, it has been referred that whatever damage which has been done by the commercial entity and commercial enterprises, they need to come, they are very much liable in nature, and the court will have to come with a certain specific principle. So then in this case, the precautionary principle was specifically mentioned, where they have said that there is a lack of information which does not justify the absence of management measures also. So these are the two opinions which has been come into picture. So time and again, when you're talking about what do you mean by precautionary principle, so as per the understanding of this case and different other cases also, we have come across that it is basically an environmental measures which has to be adopted by the state to prevent environmental degradation. But this is not only with respect to prevention of environmental degradation. There are other factors also which are important here. For example, if there is a lack of scientific certainty also, then in those cases, these lack of those mechanisms, those specific measures should not be the main excuse for postponing the measures to prevent environmental degradation. So this is something where the immediate relief, there is an immediate control over the environmental degradation is important here. Another point which is a very important part of this precautionary principle, that is the precautionary duties which must not only be triggered by the suspicion of the concrete damage, but it also a kind of a thing which is there whenever the risk is there altogether, we have to tackle those risks also. So these issues, these are the parts of precautionary principles. Now there's another case, that is Indian Council for Environmental Legal Action versus Union of India. Now in this case, it has been mentioned that whenever there is a damage to the environment, it will adversely affect the principle of sustainable development. So you see, in this judgment, the court has mentioned clearly that we need to establish the relationship between sustainable development and the environmental protection also. And it has mentioned that there is a liability upon the state to cover up these measures. So either we refer with respect to MC Mehta versus Union of India, oleum gas, either with respect to Ratlam versus Vardichan, we have found out that the community health is important. We have found out that clean and healthy environment is also important altogether. So in these cases, we have come into conclusion that there is always a challenge in the implementation of the legislation related to environment, and we have found out even the difficulty for the conviction against those persons, against those industries who are responsible for the pollution. It is quite obvious it is due to the lack of evidence and an undue and unfair trial proceedings also. Yes, to some extent we also need to develop principles where we can develop certain scientific tests so as to determine and so as to assess the environmental risk which is involved here. So that's it for this session also. Best of luck. I hope you will be able to understand other perspective of environmental harms in this situation.